Good morning, everyone. Thanks for calling into the webinar. We do have Moana Anderson, who is our 2016 president, to provide a quick introduction of our guest speaker. Moana, do you have a few words to say and provide the introduction?
Sure. Well, first of all, Happy New Year, everybody. And Seth, just to introduce our fabulous speaker, Seth Reese is an intellectual property and e-commerce law attorney, and he manages his own law firm, Seth M. Reese, while serving as of counsel to the Honolulu firm Watanabe Ing LLP. Seth received his bachelor's in biology and chemistry, his master's in biochemistry, and his jurisdiction JD from the University of Hawaii William S. Richardson School of Law, and an LLM from the University of Cambridge, England. A registered patent attorney, Seth has practiced law in Hawaii since 1980, emphasizing intellectual property and high-tech law since 1991, and adding e-commerce law with the advent of the Internet. Seth is a founder and former chair of the Intellectual Property and Technology section of the Hawaii State Bar Association. He's an arbitrator with the WIPO Domain Name Dispute Resolution Center, a mediator with the Dispute Prevention and Resolution and Mediation Center of the Pacific, a participant in governing structures and working groups of the Internet Corporation for Assigned Names and Numbers, and he's also a frequent public speaker on intellectual property and Internet law topics. So without further ado, we're thrilled to have you, Seth, and mahalo for being here.
Thank you very much, Moana. I'm very happy to be here, and I thank the Hawaii Association of Realtors for inviting me. So this topic is very timely, I think, for many of you out there, what we're seeing over the last several years. And, you know, the Internet is a big part of it, but a lot of it is photographers and other creative people asserting their rights in their works and in how they're used, particularly on the Internet, but in all forms of advertising. So we're seeing more and more claims, and realtors seem to be the target, not because they're realtors, but because they have a great need to advertise properties, and properties involve photographs, and a lot of times it's Hawaii real estate photographs, photographs of the picturesque aspects of Hawaii. So, we've been giving a few talks like this, and the talks are basically to help you avoid mostly copyright infringement claims, but we'll be talking about a few other things. So I guess I have control of the PowerPoint. Let's see if I can do this. So we're going to talk about three basic areas of protected content. One is creative content, and this is what we're going to be talking about the most, and this is primarily protected by copyright or entirely protected by copyright. The second area is people. Names, likeness, voice, and signatures are protected, and that's under a different regime called publicity rights. And then there's this area of protection for places. And pretty much we're going to tell you that places aren't protected and they're okay to use without getting a written permission, but there's some isolated exceptions, and it's good to talk about them just in case you might be involved in those exceptions. The first area and the biggest area is copyright. What is copyright? It's works of original authorship fixed in a tangible medium of expression. It should be medium, not media, but I guess that's close enough. And it can be any type of fixed media. So, but it has to be fixed, and it can be memory, computer memory, but it can't just be in the air. So the most common areas are music, sculpture, literature, layout, and architecture. And the architecture was the protection for architectural design was tacked down in a 1989 amendment to the Copyright Act. What's not protected? Well, almost everything is, but if you have something that was never recorded, then that's not protected. So if you speak a poem and it's never been written down, that's technically it's not protected. If you play on the piano and nobody records it, it's not protected. But almost everything will be recorded at some point. And as I said, even computer memory is a type of fixation. How do we encounter copyright protected materials in real estate? Well, everywhere. Photos and videos are the most obvious, but it also would include the layout and the creative aspects of a website and text. What is not protected in the text, and we'll talk a little bit more about that later, is factual information. Factual information is not protected, but the way you express the factual information is, so the textual description of a property, some aspects of that may be protectable. Architecture, as I explained, the plans are protected, and since 1989, the actual building designs, building a building, that's protected, but not the structural aspects. So if you copy something that's necessary for the support of the building, for example, that wouldn't be a problem, but any aesthetic aspect of the design is protected. And another big area for the real estate industry is databases, the MLS. The MLS is a compilation. It's protected under copyright law, and that's going to be a big part of what we're talking about today. When does copyright protection kick in? It's automatically upon creation. And it's automatic. So, you know, when your 4-year-old child at preschool draws an abstract drawing, technically your child owns a copyright in that drawing. It's automatic. No formalities are required, but formalities are advisable. 2 areas of formalities. One is the symbol, you know, the a C with a circle around it of the word copyright, and the name of the author. That's notice to the public that you're claiming copyright, and that's helpful to protection. Registration is also helpful for protection, particularly if you have to go after an infringer. It gives you a lot of leverage, and that's been the problem when realtors find themselves as respondents in a copyright claim, particularly if the work's been registered, because the penalties can be severe. Who are the owners of the copyright? Well, the owner is, in almost all cases, the creator. The owner is the author, but the author is either the creator, and usually that's the person who creates, the photographer, the writer, the designer, the person who creates and fixes the work. And there's one exception, that's work made for hire. However, the work made for hire exception is not as broad as everybody thinks it is. And this is what the work made for hire says. It's a regular employee working within the scope of his or her employment. So I'm using the MLS as an example here. I'm not sure I'm right. I'm thinking that the people who create the MLS are probably employees of the MLS. To the extent they're not employees, if they're independent contractors, then this doctrine would not apply, and in fact the MLS would not own that part of the copyright unless they take it in writing. So a regular employee within the scope of employment, and there's another exception, and especially commission work, but it's only in one of 9 statutory classes, and only if the language work made for hire is in the agreement and it's signed. So these are very limited exceptions. So unless you're an employee working within the scope, so you're the employer of an employee working within the scope, you would not own the work under a work made for hire unless you created it yourself. And we'll see how that plays out in practice. How do you transfer the copyright? Well, the best way is an assignment. It has to be in writing and has to be signed. It can be informal. It can be an email that's signed. Doesn't have to be any type of formality, but it does have to be in writing. The law states that, and you can also transfer a partial right, and this is a license. And there's 2 types of license: non-exclusive and exclusive, and then it can be carved up. So, for example, a photographer may give you the right to use a photo for an MLS listing, but not beyond that, or may give you the right to use the photo for selling your house, but not beyond that. That would be a license, and that would probably be a non-exclusive license. Non-exclusive licenses can be oral, but if it's non-exclusive, then the licensee doesn't have the right to enforce. So, for example, if somebody infringes the photograph and you're a non-exclusive licensee, you can't do anything about it, but the photographer who owns the photograph can. So how do we how do we encounter copyright in real estate advertising? Well, the most obvious way is websites, but also brochures, flyers, media ads, architectural drawings. For example, if you put the architectural plan as part of the marketing material for the building, and the MLS. But the websites where we're seeing most of the claims, and that's because websites are becoming more and more important for real estate advertising, and it's the easiest place to slap up a photograph that you may not have the right to slap up. This is why claims can be very, very painful. The copyright infringement penalties start for works that were not registered prior to infringement, so the regular rule is compensatory damages, and that's both the injury and the benefit. You can get both what you should have paid for the photograph plus any benefit you obtained. And I suppose I'm speculating here, the biggest claim would be if you sold a house and the photographer is going to say, hey, but for my photograph, you wouldn't have sold that house. I want your commission. And that sounds pretty severe, but technically that's an argument that can be made. I don't know if a judge or a jury would agree, but potentially that's possible. So that's just the normal kind of damages. Now, if a photograph was registered with the Copyright Office prior to a first infringement by you or whoever was infringing, then you have the possibility of statutory damages and attorney's fees. The statutory damages can be as much as $150,000 per work. And the reason why we have that in the law is because usually it's not cost effective to sue somebody for a small infringement, so the law provides this so that it dissuades people from adopting a photo or a creative work because it's convenient. So in other words, if you slap a photograph on your website, it wouldn't be worth suing you for compensatory damages because maybe you only get a few $1,000 license fee at the end of the lawsuit. However, if there's a potential for statutory damages, which are in there as a deterrent, and the judge or jury may award something of that nature, then of course you're less likely to infringe. The $200 for innocent infringement. So we'll talk a little bit about this later. But innocent infringement is very rare, and all it does is get you a decrease in damages. So in a statutory damage scenario, if the judge or jury determines you're innocent, you didn't know and you shouldn't have known that it was a copyrighted work or you were infringing, then they can lower damages all the way to $200. The problem is there's still defense costs. If the work was registered prior to the first infringement, the claimant is also eligible for attorney's fees. In the typical copyright case that goes to a judgment, attorney's fees are going to be in excess of $100,000 and sometimes $200,000 or $300,000. They're very expensive suits to litigate, and to get to a result, you have to go generally all to the end of the case because oftentimes it's fact intensive, which means you can't short circuit the legal proceeding. And so at the end of the day, it's usually the attorney's fees that are the biggest potential liability. So that's what you're gambling on either side. How do we encounter copyright infringement in real estate advertising? Typically photos on websites, magazine, TV ads, and then the MLS. The MLS is protected compilation and having its own copyright. And the claimants were normally are photo stock companies. There are mainland companies like Getty Images. There are also local companies. Pacific Stock is a local company, and so and individual photographers will also make claims. The way they find the infringement is very easy now, and anybody can do it. There's search. You can scan your image in and then ask I think it's Google, or you ask Google or another search engine to find similar photos on the internet. So it's very easy to find potential infringers. So even we've had cases in which a blog was archived 3 years ago, and the claimant finds the photo in an archived blog on some archived website somewhere, web page somewhere. So it's easy to find infringing photos if they're on the web, and this has really changed the nature of the legal environment, because years ago, before the web, the chance of your brochure getting picked up as infringing was much less likely than something on the internet. So typically you get a demand letter. There's usually a negotiation to settle. The demand letter is usually shocking because they're asking many, many times a normal license fee to settle. And if you don't reach a settlement, then a lawsuit's typically filed, particularly if it's a local claimant. This is another area you can find yourself having liability for copyright infringement, and this is not something that is at all intuitive. When you like a photo on Facebook, you're actually reproducing the photo on your Facebook site. If you repin on Pinterest, you're reproducing it, and if you reblog on Tumblr, you're also reproducing the content in the photograph. Now, Facebook, Pinterest, and Tumblr encourage you to do this. The problem is, and they give you a license to do this in the sense that you have a license from the person who posted it, but if the person who posted the photo or the content initially does not have the right to do that, then you end up with liability. This has only happened, to my knowledge, on commercial websites. So in other words, if you have a personal website and you're not advertising a business or real estate, and you like a photo that shouldn't be up there, or you repin a Pinterest photo that shouldn't be up there, you're probably not going to get a copyright claim. However, if you have a commercial website, a real estate or other commercial website, and we have seen this, we have seen claims, and we have been involved in proceedings in which somebody repinned a Pinterest on a commercial website, and they ended up with a copyright infringement claim. And Pinterest won't come in and protect you, and you can't really do anything because the terms and conditions of Pinterest basically say it's your problem. So again, if it's a commercial website, you should not be repinning or liking if it is unless you know the origin of the photo and you know it's authorized. If it's a personal website, you're technically probably still infringing, but it's very unlikely that you would end up as the respondent of the claim. Who are bringing these claims in Hawaii? Local photographers, both local and mainland stock companies. We recently encountered a company called LCS out of Seattle, and they're basically a company that takes rights from photographers all over the world who want their photographs policed and want to get income from unauthorized uses. And I know that this is trolling. It's termed trolling, but basically what's important to understand is if you're a photographer and you own photographs, you would have the same motivation to make sure that you're compensated for their use. And so the term trolling is a little bit misleading because what's going on is not illegitimate. It's just uncomfortable, and it seems severe at times. And some companies may use practices that don't feel ethical, but they're not illegal. So for example, LCS is not even a law firm. They will just send letters, and they'll say, if you don't settle with us, that we'll refer you to a lawyer. They'll send the matter out to a lawyer. These settlements, the LCS settlements, the ones we've seen have been pretty low, under $1,000, and it's almost always easier to settle than to take the issue up, even if you believe that there's a possible defense. The other claims by the stock companies usually are many thousands of dollars, but those also are generally better to settle than to litigate. But there will always be the occasional case where there's a real defense and it's worth taking up. If you license photographs up front, you're looking at $1,300 to $1,500 for a website license, typically, depending on the company and the quality of the photo and the photographer. What happens is if you get caught and you're getting claimed against, then these numbers go up by at least a multiple of 2 and maybe several multiples. So, and again, it's cheaper to settle than to fight these things. Some examples of how these cases have come up on Realtor and other commercial sites. I don't know if this happens a lot these days, but in the old days, the early times of the internet, people used to have these PowerPoints that they just passed around with wonderful, beautiful photographs, and nobody knew where those photographs came from. And your friend would send it to you and say, "Boy, look at how beautiful these things are." That's fine until you pick up. Well, it's technically infringement, but it will not get noticed until you pick up a photograph and put it on a commercial website. One person did this, and sure enough, the photographer or the photo stock company noticed and filed a claim. What's happened a lot, there's a couple of fairly well-known and quality photographers in Hawaii. They're known for Hawaii landscapes. Their photos got away from them and were showing up on download for free wallpaper sites. Most of these sites are outside of the United States, so there's no way to really police them or get them to take it down. And then when people would find a wallpaper for free, even though you're only supposed to use it as wallpaper, people were on your personal site or your personal computer, people were using it on commercial sites, and they got sued. And this is still happening. So be very careful for download for free. And whenever you see a website that says you can use these photos, no problem, you have to look behind the website. And more often than not, those websites won't be located in the United States, and they don't have any real validity. And so if you do use the photograph and you try to rely on the website, you'll find that there's nobody there to protect you. Another case, somebody had a blog with editorial content. It was in an archive. That was the one that was 2 or 3 years old, archived, and was still noticed by the photographer or the photo stock company. We talked a little bit about a Pinterest repins and Facebook likes. Again, these were commercial websites that were claimed against. And the conservative advice, and probably the right advice now, is if you have a commercial website, do not repin from Pinterest and do not like from Facebook unless you really know what's behind the photograph and that it's up there legitimately. And another case we had, which was interesting, there was a software developer, website developer who licensed website software, in which there was little photos as placeholders, and you're supposed to use the software and put your photo in the placeholder. Where in one case, they didn't put their own photo in the placeholder, and they used the placeholder photo, and sure enough, the Seattle LCS company came and said, "Hey, you can't do that." And we said, "Well, we had a license from this WebVolter software," and they said, "Well, we didn't give them a license." And the software company was in Europe, so again, the settlement made more sense than trying to raise an issue that would be difficult. What are the defenses? Well, a full-on defense is a license that you have a license to use. Oral licenses are possible, but again, they're hard to prove, so any kind of writing can be informal, any kind of writing works. But a lot of times, the use is outside the scope. So for example, if you license an image from a photo stock company, but you use it more extensively than that license says, that's an infringement. That's outside the scope of your license. Innocent infringement is not a full defense. Copyright is strict liability. You don't have to know you're doing it. Just like trespass is strict liability. You don't have to know you're doing it. So what does innocent infringement get you? Well, it gets you mitigation. Under the statutory damages, the judge can lower it to $200. What is innocent infringement? Well, innocent infringement usually isn't, I didn't know it was under copyright. That's almost never an innocent infringement. Innocent infringement is having a license from somebody who didn't have any right to license it. So in other words, if you rely on a license under circumstances where there's no reason for you to doubt that it was the person had authority, then that would be innocent infringement. And you shouldn't be hit with too many damages. The problem is you still have defense costs, and it still costs you a lot of money paying your attorney to defend you and establish that defense. So it can still be very expensive. So again, settlement's usually cheaper than actually establishing innocent infringement. So for example, when we're dealing with companies who are claiming to settle these lawsuits, one thing we need to know is, do they have authority on behalf of the photographer to enter into a settlement? So we ask them for a representation. If one of those representations end up being incorrect, we're here with the innocent infringement. We think it's going to work well. We're not going to get hit with a lot of damages, if at all, but we're still going to have the problem of defense costs. So the best you can do is try to ask for representations from reputable companies, but unless you go all the way to the photographer, and that's oftentimes not possible, you can't be sure that you have a full defense. Fair use, well, everybody wants to use fair use. First of all, it's guesswork. It's a subjective test with many factors. It's very hard to establish. It's always fact intensive, so you always have to go through a long trial process. You can't short circuit this defense in court. You basically have to go through most of the court process to get a judgment. You won't know what the result will be until the end. It will cost you a lot of money in defense costs, and it's very difficult to establish for a commercial site. So a lot of times people say, well, I'm using this fairly because I'm making fun of it, or I'm using it in a different way, or I haven't used it at all, or there's some educational aspect. Well, that almost never works for a commercial site. And the reason why these cases come to judgment is usually because somebody feels very strongly. It's not cost effective. Attorneys would love to take these cases because they're interesting, they're fun, but they're very expensive. And so from a cost-effective benefit, it doesn't make sense. And you may still have defense costs. Now, the way the attorney's fees rule works in copyright cases is defendant gets their attorney's fees if they win. Not always, but many times. However, if it's a close fair use case, even if you win, the judge is not likely to give you defense costs. If it's a slam dunk, he may, she may, but it's not something to bet on, even if you think you have a good fair use case. So we hear a lot about fair use. We always argue it, but in settlement negotiations, but in reality, it's a rare case. So the copyright defenses, if you've used it and you don't have a license, a real license, then there's not much else out there. Let's see. Ownership, well, whenever you use outside commercial photographer, web designer, ad agency, anybody who's not an employee working within the scope, they own the copyright, you do not. Okay. So what are you getting for your money? Well, you're getting the right to use it in the way that your agreement with them states. So if you hire a commercial photographer, usually there are limits into how you can use the photograph. And if you want to use it beyond that, you have to go back and ask for the permission, pay more, or you can do a buyout. Commercial photographers should have terms and conditions telling you what you get and what you don't get. When you do an ad through an ad agency, the ad agencies will normally get the rights for that ad, but again, that's not yours. You don't get to use it again or in a different way or beyond that. You can usually ask for more. Sometimes there's a possibility of buying out. In the area of photography, it's called a buyout or buy the negative. And so sometimes you can, sometimes you can't, and sometimes you can negotiate a broader use, and sometimes you can't. So if it's going to be important to you to be able to use it any way you want, then shop around for photographers until you find one who will let you. In other words, once the photograph's taken and you enter into a limited agreement, you have no right to demand more use. Oftentimes, typically you can do a buyout, but not always, and it's entirely up to the photographer. Photo stock companies read the fine print. Generally there's very wide usage allowed from Getty Images or other photo stock companies. Usually it's not a problem to get a broad license for a little bit more money. However, not everything's possible. One thing that's generally not possible is the right to modify a photograph. If you modify a photograph, it's called derivative work, and normally photographers and photo stock companies will not let you do that. But again, if you're negotiating directly with a photographer, anything's possible, and if you buy the rights, then you have the right to modify it as well. If you buy an assignment, if you take the whole thing, you can modify it. There's a couple of things on the internet that are actually produced by this organization, the national organization. One is Who Owns Your Property Photos. That's a short article, and basically he's telling you the same thing I just told you. Another one that I found is a longer presentation put on by a law firm, mainland law firm, and it basically is more extensive discussion of copyrighted photos as it relates to the real estate agency. Since this is the national organization, you should take advantage of these articles. So shifting into, let's see how we're doing in time, shifting into things other than photos. Property description, well, as I explained earlier, facts are not protectable by copyright, but expressions are. So you can't, if there's a long description of a property, it would be a copyright infringement to borrow that intact, but if you extract the facts and express it in your own way, you are not infringing the copyright in that text. Something that is very short is not protectable by copyright, so in the words of the Copyright Office, slogans cannot be protected by copyright. However, a whole sentence, if the sentence is elaborate enough, can be, and it's guesswork to say, what in between can and cannot be. So, once you're beyond a slogan or a very short phrase, you have to be careful. MLS, this is big because MLSs are becoming more and more valuable, and they're being used in more and more ways. So it's very clear that databases are protectable by copyright. What's protectable? It's actually the arrangement and the organization of information that's protectable. Again, facts are not protectable, so it is the organization. But of course, that's the very value of a database is the way it's organized. So everything valuable about MLSs are protected by copyright. The copyrighted MLS is owned by the MLS, even though the facts are provided by the subscribers. These days, the MLSs are being licensed to larger organizations. The National Association of Realtors, the parent organization of this organization, is actually engaged in licensing MLSs through the RPR. And there's also licenses going to Zillow and a number of other publicly available larger databases. And the arrangements are getting very complicated. It's beyond the scope of this talk, but it's enough to know that the local database, copyright protected database, is the local MLSs, and they are being licensed on a broader basis to a number of different ways. And as we explained, you can license in any of a variety of ways. You can license part of your information. You can license to only certain sectors. You can license to only different geographies. You can license in different periods of time. So the varieties are endless, and it gets quite complicated. Referring to our local MLS, this would be Honolulu-based because I'm not familiar with the other ones. And that's High Central MLS. The rules of the database are contained in the rules of the MLS. Rule 12 gives participants, and these would be the realtors and the participants, I believe, a limited license to use the MLS. That's part of the membership. And the Rule 10 also says all the information is confidential, which is kind of interesting. Obviously, when the information is displayed publicly on something like Zillow, that can't be confidential, but anything that's not publicly displayed can be. And so my understanding of why we have Rule 10 in the rules is when you maintain something as confidential, that anything that's not protected by copyright can be restricted. So copyright restricts the non-confidential compilation, and anything else can be restricted through a variety of contractual agreements, which is what the MLS rules are. Rule 11 talks about ownership of the MLS and the copyright in the MLS, and it states that the compilation is owned by the MLS, but obviously each participant is contributing to that compilation by providing their listing information. And so the pieces that are contributed may have copyrightable content that is owned by the contributing party. So this makes everything very complicated. So let's take a photograph. Now, the photograph of a house that's contributed to the MLS by a broker, that comes from somebody. It could come from the broker could take the photograph, the agent could take the photograph, the homeowner could take the photograph, or a commercial photographer could take the photograph. Ultimately, the broker or the agent contributes that photograph to the MLS if it's appearing in the MLS. And the question is, who has authority to do that? Now, Rule 11 of the rules of the MLS rules state that when you contribute content to the MLS, you're representing you have the authority to do so, and that's it's like almost providing a warranty. It's a representation that could be sued upon, and so just like when you post to Pinterest or post to Facebook, you're representing that you have the right to do that. So what if a commercial photographer finds his or her photograph in the MLS and doesn't belong there? Well, the photographer would potentially go against the MLS, and the MLS would look to the broker under this Rule 11 to be indemnified or reimbursed, and the broker might look to their sales associate, and the associate could potentially look to their client if the client produced the photograph. So you have this kind of chain of claims going on, but I think the message here is before you introduce a photograph into the MLS or your website or otherwise, try to figure out where the photograph came from and make sure that there's no problems using the photograph in that way. And the other message here is when you're contributing any contact to the MLS, you're basically saying, I have the right to do this, and nobody's going to come along and sue the MLS or anybody else for using that photograph or content. In October 2015, the High Central started watermarking MLS photographs. The real purpose of this was to prevent unauthorized use of photographs for things like Craigslist, but it also has copyright implications because it also makes it easier to track photographs for purposes of copyright infringement. There's a part of the copyright law that was introduced, I think, in the late 90s, called the DMCA, which makes it an additional claim if you remove identifiable, well, it's called copyright management information from images or from copyrightable works. So if there's a signature, if there's a watermark, anything that identifies a photograph on the photograph and you remove it, you have another claim against you in addition to a copyright claim. So that's important. It's important to know because you may be doubling your trouble. The other thing that may be of interest is that the Hawaii Associated Realtors standard forms that are created by the Standard Forms Committee, a lot of work goes into them. They are under copyright. As we explained, everything's automatically copyrighted. HAR has gone to the trouble to register the copyright in these forms. But the forms, by their terms, are licensed to the entire real estate industry. This is a policy decision because it makes the forms usable if there's consistency in the use of the forms. But they're technically under copyright and they technically cannot be used outside this license. The license is printed on the top of the forms. And so using the forms for other reasons or outside the real estate industry technically would be an infringement of HAR's copyright in the forms. Okay, so we're going to talk a little bit about less important subjects now. One is right of publicity. Right of publicity says that you cannot use a person's name, likeness, voice, or signature without their permission in publicity. Again, this is not news, it's not fair use, it's when you use something for commercial advertising. This was a common law right for many years, and more recently in Hawaii it's been codified in a statute. It applies both to alive and dead people if they're recently dead. And then again, there may be a right of publicity in places, but it's very thin, it's very, very rare, and it's not something you would need to worry about often. These are cases, historical cases in Hawaii that established the right of publicity in the common law before we had a statute. And so the right was kind of fuzzy under common law. Statute makes it clearer. Interestingly, the premier case in Hawaii was, these are the only two cases, I believe, but the premier case was actually a real estate case. There was a brochure, I don't know, Hawaiian Ocean View Estates, one of those, the lava land being sold in the 60s in the Big Island, and they took some recent buyers or sellers. They took photos of the people and used them in a sales brochure and TV commercials without their permission. The Fergusons discovered this and didn't like it, so they brought a claim. There's also, I don't know who remembers, Aku Pupele, a radio personality. So I think it was his voice that constituted the claim in that case. More recently, we have a statute. The statute clarifies the right. It makes it very clear so that you can't debate it anymore. There's still a First Amendment fair use defense, so that your use of your photo, for example, in a news story would not be actionable. It's just commercial use, and it also tells us how long. It's lifetime plus 70 years, even if you didn't exploit this right during your lifetime. So under common law in some states, you had to be a personality to have the right after your death, like Elvis Presley, for example. But under the statute, it makes clear that even if you never got money for your personality during your life, your family could protect it 70 years after your death. Just like other intellectual property or intangible property, you can transfer, assign, and license it. You can register it with DCCA. The value here is providing notice, so it's not a bad idea if you're a personality. And you have some remedies here that are not bad remedies. How about in things? Well, the rule is that if it's not a person, there's no publicity rights, and that's something that you can pretty much rely on in almost all cases. There's a couple of exceptions. The Reynolds tobacco case is a case in which a race car driver was associated with so closely associated with the number on his car that when a car with that number showed up, he could sue and write a publicity. I think this would be true, Mariota. We have, what is his number? Anybody remember the number on his? If you saw a jersey with, with the Oregon colors with his number on it, that might be enough for him to come out with write a publicity case. So you're not only showing the jersey, but it's really you're representing him, and so it is a right of publicity. So that's one thing to worry about. The other thing is, a very distinctive building. Now, there's no right of publicity for the owner of a building, but there could be what's called unfair trade practice, and we do have one of those in the state of Hawaii. If you do something in commercial advertising where you imply endorsement, sponsorship, or approval, that can be unfair trade practice and give rise to an action, kind of like a trademark infringement case, but not really. So how would that come about? Well, I give some examples, and I don't think any of these are relevant. The Governor's Mansion, Pearl Harbor, and the Art Academy are such public buildings. It's not likely they give rise to an action unless you did something with the Art Academy that would imply to the consumers that the Art Academy itself was endorsing or sponsoring the product. In other words, if it was an piece of art, for example, and there would be a reason why consumers would believe that the Art Academy was actually endorsing the commercial product, then there could be an action. Shangri-La, I think I left the R out of there. But anyway, that also gets a little closer because it's such a unique property that it's more likely that a commercial advertisement with that property on it could be said to suggest sponsorship, approval, or affiliation. But in most cases, using public landmarks or buildings or things will not give rise to that association, and it's not something you would have to worry about licensing. Actually, I was told about a recent case where there was a depiction of one of our large hotels on Maui, I think it was, and there was a suggestion that they had to get a special license. And my understanding of that case is there was concerns with competitive, it was the way the hotel was franchised, and it was concerned that there might be, again, it was a competition concern. It wasn't really an intellectual property concern. But this is something to think about, at least. Okay, this is probably the most important thing of the slide. So there is insurance for most copyright claims, and the insurance is your general liability policy, commercial policy. It is not your E&O policy. E&O protects you for professional mistakes, but not copyright infringement, because the copyright infringement we're talking about will oftentimes be in the context of advertising. There is a coverage in most commercial policies that cover advertising injury. There includes copyright claims that arise in the context of advertising. One thing is that most insurance companies like to tell you no the first time around, and so you shouldn't take no for an answer. It will depend on the policy. There's some policies where they're excluding some of these coverages, so it won't work in every policy. It depends on the insurance company and on the circumstances. There has to be some aspect of advertising in the claim. But the important thing to remember is it's your commercial policy, and don't take no for an answer at least the first time around, or get a professional opinion whether coverage is properly denied. E&O, there might be a rare occasion where these aren't covered in the E&O policy, so it may be something that you want to consider tendering, at least checking into. So let's see, masters have liability for their agents, so brokers end up with liability for what's done by the agent. On the other hand, technically, employees have to compensate their employees for mistakes of this nature. I'm not sure that's commonly done, but theoretically it can be done. And another thing, very important thing to consider is that the normal corporate shells that we all rely on to avoid liability do not work for IP infringement. There's doctrine of secondary liability, which says that if you are aware of and have the ability to control against infringement, and you're a principal or a manager of the shell, the company, you can have personal liability. And this this is very useful to claimants because people can't just simply rely on the corporate shell to avoid liability. So we're finally done, and I have to remind you to type your questions in the question bar. That's on the right of your screen, and we'll try to answer them. Hopefully this was clear and will be of assistance to you in your work, in your business. Do we have any questions yet?
There were some questions during the session. Right here, I highlighted it.
Okay.
I'll repeat the question. I took a photo of a new article from the newspaper and I posted the photo of the article on my Instagram. I took it off because I did not know if that was okay.
Okay, so that was a good decision. Photos in newspapers, again, it may be fine for the newspaper to use it because it would be fair use, but it wouldn't be appropriate to use it in commercial setting. Photos in newspapers will come in two varieties. Oftentimes a newspaper will buy the rights to the photo, license the photo, or it was shot by a newspaper photographer. If there's a newspaper photograph that you want to use, you might check. There's a photo editor with most newspapers. You can check with the newspaper to see if they will let you use it in the way you want, and always get something in writing so that it's not an oral permission.
Okay. Another question was if this is being recorded. It will be recorded and circulated to you later, probably in a day or two. Question from the Big Island. How does one register their work, photography?
Okay, so the Copyright Office has a very user-friendly website. It's copyright.gov, and it has everything you need to register your copyrights. Now, it includes publications that basically have a step-by-step instructions on how to register your copyright. There's a e-copyright interface where you can do your registrations online, and it's very inexpensive. It's somewhere between $35 and $45 depending on the circumstances, I believe, for each registration. There are a couple of trick questions, like we've talked about the work for hire doctrine. There's answers in the copyright website, because if you go to the brochures that talk about ownership and work for hire, you can read about them and pretty much learn everything you need, but there are some questions that may be hard to answer without doing your homework. There's also, of course, copyright attorneys like myself that you can go to for assistance, either to get assistance to register or to have them register for you. But the Copyright Office is generally set up so that lay people can do their own registrations. Also, registrations are fairly forgiving, so if you don't make serious mistakes, then your registration wouldn't be invalidated. The one caveat is it's usually very difficult to get through to the Copyright Office on the phone. There are helpful people there, but they're not often available. Okay. Do we have some more?
Yeah, we do have a few more. I believe
they're coming in.
They are. The question that you just answered regarding the registration of work, I guess that's the same thing as a patenting.
No, it's very different. There's different types of intellectual property. We talked about two of them today, copyright and right of publicity. We touched on trade secret a little bit because the confidentiality provisions of the MLS touch upon trade secret. But there are two other big areas. One is trademark and one is patent. They're very different from copyright. Patent has to do with inventions and not creative content. Trademarks have to do with logos and slogans. So the procedure for registering patents are very different. It's very complicated, very expensive, and it's almost impossible to do yourself. But it wouldn't be appropriate for photographs. It would only be appropriate for inventions.
Good question. Music used for ads, i.e. underscoring for virtual tour must all be licensed.
Yes, and this is like photographs. People oftentimes borrow music without a license, and they end up being end up with a claim against them. License, yeah, music like photograph is almost always protected by copyright. The rule is, you know, if it was created before 1920, then it's not under copyright anymore. So that's not a lot of music. In recorded music, you have two layers of music. You have the composition. So if it's Mozart, well, the composition might not be protected, although a recent arrangement would be. But you have the recording. A recording of music has a separate copyright, and recordings are always protected unless it's before 1920. You have to get a license. There are website licenses available for a lot of music by going online to the, it's called the HFA.org, I think, Harry Fox Agency, and Universal Music also has a lot of music for licensing. But just like a photograph, if you don't license the music, unless you play it yourself, you compose it yourself and play it yourself, you could face a copyright claim.
A lot of Facebook-related questions. So let me start with a couple of them. Same question as the Instagram question. Does that apply to Facebook when posting a link that generates a photo and a link? You mentioned violations by liking Facebook and Pinterest for commercial sites. What about Instagram for commercial sites?
Okay, so one problem I have is my age. I'm not familiar with all the platforms, and I don't use Instagram. But logically, the same rule applies. Now, the problem with commercial sites is that they're up there, and photographers can find them. So a commercial Facebook site, a commercial Pinterest site, a commercial Tumblr site is up there for people to see. Instagram, I really don't know if it functions like a site, then the same rules would apply. If it's just a fleeting text that you receive and disappears, there may be an infringement, but the risk of getting claimed against may be lower. So I better not comment beyond that because I'm not familiar enough with the platform.
This is a good question. I use my Facebook for both private and business. Would my site be considered commercial? When other agents I work with ask to like my page regarding a listing or share, do I run the risk of liability?
Yeah, if it has a commercial aspect at all, it's commercial, and you run the risk of liability. Whether or not it's commercial, but there's much higher risk of liability. Again, you only have liability if you like something that shouldn't be up there in the first place. But since you don't know where photos and content from other people's sites come from, and you can't be sure that they're up on the web legitimately, then you run a risk. So consider the fact that if people post something on their personal website, they're running a low risk because it's a personal website, and then you like it onto a commercial website, you're basically becoming the target because you're using it in commerce and you're more likely to get claimed against.
This question's a little specific. I've had 2 occurrences with notifications about copyright infringement. My webmaster verified and wrote to Getty Images that images and articles were from a free RSS feed, which dropped the case on both occasions. Because it was such a hassle, I did remove these feeds from my website and only posted my only pictures and blog in my own words. So I do suggest addressing issues to your webmaster prior to just paying the fee. Not really a question, I guess.
Yeah.
A bit of a
That's fine. I'll leave that as it is. I'm not sufficiently familiar with RSS feeds to know whether that's a good defense, and I don't know why Getty Images may have dropped the case, but it is true that if there is a defense, it's worth raising, and if the claimant is reasonable, they may agree that they won't enforce it. We did have a case recently where when we pointed out that the respondent was a nonprofit, they gave us an 80% discount for a settlement. So when we suggest settling, we don't suggest just giving up and paying the demand. We suggest engaging in the conversation. And you'll find some claimants being more reasonable and more flexible than other claimants.
Okay, thank you. Just a question. What does it take to cost, how much does it cost to patent an item, and how long does it take?
Okay, this is outside the scope because I don't think patents are relevant, but it takes years and it costs many, many thousands of dollars.
Simple enough. If you have a complaint that another agent is using your property photo, do you have cause, or only the photographer can enforce the complaint?
Well, as we said, if you have a non-exclusive license, you technically don't have enforcement ability. However, there's nothing to stop you from contacting the other party and telling them that they shouldn't be doing that. But you couldn't bring the lawsuit. But you could always contact the photographer and ask the photographer to join with you in the lawsuit.
There's a question about adding watermarks to photos. There are programs out there. You can Google watermark programs or online sites that actually do it for you to add watermarks. Just a statement, newer digital cameras on copyright. Well, I guess the newer digital cameras will be able to put on some type of watermark or marking with these newer cameras. Do you have a form for licensing photos and 3D tours?
No. Licenses don't have to be long or complicated. Sometimes they are. Because licenses can come in so many different forms. There aren't just one form fits all. The HAR article that I had a link to in one of the slides does have forms that may be appropriate to certain situations, but in my practice, I would normally have to first interview the client to find out what their needs are and what the parameters are, and then I would draft up something that could be just 1 or 2 pages. It doesn't have to be complicated, but it usually has to be tailored to the situation.
Okay. I guess this one might be a 2 set of questions, but I'm not sure. Can you post a link or refer to a commercial website on your business Facebook or a personal website without the approval of the owner? I guess one is business Facebook and one is personal website.
Simply providing a link to another website, so I'll answer it that way, normally will not incur any liability. There's been a few cases in which, for example, if there's a website that's notorious for providing infringing images, the Napster, if you point to a case that has illegal sharing and say you can share illegally there, that could give rise to what's called secondary liability, but simply posting a link, particularly to a website that's not notorious for illegal activity, will not create liability.
Last question.
Yeah, so I think that answers this. Okay. So that's irrespective of business or personal.
And this is our last question. Is it okay to have people in your MLS listing photos without any permission?
No. If you can recognize the person, you should not have that without a permission. The permission could be a simple writing. So, if there's no magic about the permission, but you need permission, otherwise you run afoul of the right of publicity statute, because people do have the right to control how their image is used for commercial purposes. Again, commercial purpose. MLS would be a commercial purpose.
Okay. I have a personal question.
Okay.
So I have I see a landscape photo that's on a website. Right. It looks great, but I crop it.
Right.
And I crop maybe 2/3 of it.
Right.
Can I use that portion and put it on my commercial website?
No.
No.
Okay. So the rule is substantial similarity. So if, in the end of the day, the judge or jury decides that what's left is not sufficiently distinct to the original photo to be substantially similar, then you might win your case. However, as a claimant, claimants almost always say, hey, that 1/3 is just as important as my whole photo. You'll have all your defense costs. So the answer is don't do it. Another interesting question is, if something is staged perfectly, can I go back and take that photo just like that other person's photo did? Hanama Bay just like that, with the sun just like that? The answer is maybe, but staging is part of the copyright. So if it's too close, the person who took the original photo could claim. Again, you might win, but you may not, and you will still have your defense costs. So the answer is stage it differently, and don't crop, unless you're taking. If you take so little of a photograph that the photographer wouldn't recognize it, you're okay.
Okay.
But then, of course, you won't get claimed against anyway.
Thank you very much for your valuable information. This concludes our webinar, and you shall get an email within a couple of days with a copy and a link to the recorded version. Thank you. Thank you, Seth.
Thank you again for having me, and Happy New Year, everyone.